Morning, everybody. Good morning, everybody, and we're delighted to welcome you all here this morning in person and online to the launch of the FLAC's annual report for 2021. We extend a special warm welcome to the Chief Justice, Mr. Justice Donal, who will launch the report, and to all of you, many friends of FLAC over many years. I see Ms. Justice O'Malley, who's a former chair of FLAC, many who actively volunteer with us, working with us in various ways. It's really great to see so many of you here. After the Chief Justice formally launches the report, we'll hear from Eilish Barry, Sinead Lucy and Paula Joyce, who will talk about various aspects of FLAC's work during 2021. None of this work would be possible without the essential support and commitment of FLAC staff, FLAC's volunteers, funders and supporters in many other ways. And on behalf of FLAC Council, I would like to extend our sincere thanks to all of you who helped FLAC in those various ways. The title of this year's report is Towards Equal Access to Justice, and it speaks to FLAC's core objective since our foundation in 1969. And in 2021, the pandemic continued to loom large over our lives and over the work of FLAC. But we've also started to emerge from its shadows. And by calling into question the way we work and live in so many fundamental ways, the pandemic also gives us an opportunity to reflect on how we pursue our work, and here in FLAC, how we pursue our objective of moving towards equal access to justice. Even leaving aside the pandemic, recent years have seen significant challenges to the rule of law and access to justice in Ireland and internationally. And in particular, we've seen serious challenges in jurisdictions from which we have traditionally drawn a lot of inspiration in our legal system here in Ireland. And while we're very fortunate to have very robust institutions of government and an independent judiciary here in Ireland, these challenges are a stark reminder of the dangers of complacency, of the vital role of those democratic institutions, but also of the justice system, including the vital safeguard of judicial review, both of legislation and administrative decisions. We at FLAC believe that there is a vital opportunity now for Ireland to show leadership in the field of access to justice. In recent years, we've seen strong efforts to promote Ireland as an English-speaking common law EU member state, as a venue for resolving legal disputes and a jurisdiction for resolving high-level commercial disputes in particular. And these efforts are, of course, very welcome. But we must also have a similar level of ambition for our justice system more generally, and in particular, seek to ensure that the justice system is adequately resourced, with sufficient numbers of judges, court staff and professionals, but also sufficient funding for vital elements such as legal aid, so that the justice system is accessible to those most in need of its assistance in order to vindicate their rights. And that's why we welcome the Minister for Justice's comprehensive review of civil legal aid, which has recently started its work under the chairpersonship of former Chief Justice, Mr. Justice Brian Clark. And while Chief Justice, Mr. Justice Clark established an Access to Justice working group, which brings stakeholders together to consider how we can tackle the very difficult access to justice challenges we see in this jurisdiction. And at an excellent conference which took place in October 2021, it was clear that legal aid is an important part of that jigsaw, but there are very many elements to tackling access to justice problems which require a multifaceted response. Closing that conference was our special guest for this morning's launch, Mr. Justice O'Donnell. After a distinguished career at the bar, Mr. Justice O'Donnell was appointed to the Supreme Court in 2010 and appointed the 13th Chief Justice of Ireland in October 2021. During his time in the court, Mr. Justice O'Donnell has delivered many landmark judgments, in particular in the field of constitutional law. A keen observer of FLAC's photo archive will be able to spot a fresh-faced Donal O'Donnell at an early FLAC meeting some decades ago. During his time as a barrister, Mr. Justice O'Donnell was also involved in very many landmark cases, and one in particular stands out to me as a very junior lawyer. I was fortunate to see the Chief Justice in action in the McCann case in 2009, where acting for our friends in what is now CLM, he successfully argued that provisions of the enforcement of court orders legislation, which allowed for the imprisonment of people for debt, were contrary to the Constitution. And since taking up the office of Chief Justice, the Chief Justice has continued the valuable work of the Access to Justice Working Group. So it's a particular pleasure for me to invite the Chief Justice to launch FLAC's annual report for 2021. Chief Justice.
Thank you very much, David. I believe that in addition to the photograph David referred to, that there's a photograph in existence of a protest march organised by FLAC in or around 1979 to commemorate the first anniversary of the publication and non-implementation of the Pringle Report on Legal Aid, and that protest involved the presentation of a birthday cake to the Department of Justice. The photographer, Derek Spears, as I seem to remember, did a really admirable job in giving the somewhat misleading impression that a substantial protest had brought Stephen's Green to a halt. But even a photographer as skilled as him could not have made the young, or indeed the older, Gerard Hogan look like a member of an angry mob. Or perhaps me, as I was standing close to him in a crowd at the time. And if that photograph had been taken a few years earlier, that might have included young John McMenamin or Frank Clark, who were both to play key roles in the landmark case of State Healy and Donahue on the right to criminal legal aid. And of course, if taken any later, would certainly have included a young Ezo O'Malley, who I'm glad to see here today, and any number of persons who have now gone on to become judges in the courts. Now, in this era, it's perhaps not unusual for images from student days to emerge and be a source of some embarrassment. Often, the only question is whether more embarrassment is felt by the individual who does not want to be reminded of a radical event, a radical past, or the organisation that does not now want to be associated with established figures. Perhaps what was unusual, and indeed if not unique about FLAC, is that images like these are not, I hope, embarrassing to either party. That is, at least if you can ignore the fashion and the dodgy haircuts. The foundation, a little earlier of FLAC, brought together a number of students from very different parts of the political spectrum, and perhaps lived up to Kevin O'Higgins' famous description of the first government of the state as the most conservative revolutionaries imaginable. At different times, that was a source of some frustration to some people who hankered for a more radical group which would be aligned more closely with other causes, pressure groups, and political views. That was a view which I could and still can understand. But I believe that the breadth of support for FLAC that David has referred to has been a source of great strength. Back in the 1970s, when many people were still fired with the ideals of what was called the 60s generation, there were some who argued that the object of an organisation such as FLAC, which provides voluntary services which arguably ought to be provided by central government, should be to achieve its own demise. Success was if the organisation no longer had any work to do. This report is a very impressive production and a catalogue of work done so well. But I have to tell you, David and Eilish, that it is evidence on that score of a monumental failure. The detail of the report is eloquent testimony to the continued demand for voluntary legal services, whether in person or by phone support or by pro bono action or public interest litigation, traveller and Roma representation, or the promotion of education. So I think it's time, perhaps, to change our definition of success. Looking back at the situation in 1979, what constituted success seemed easy. The gold standard for civil legal aid, and indeed criminal legal aid, was the system in the United Kingdom. The Pringle Report was while valuable, fell well short of what was needed, and failure to implement the report, and the fact that persons seeking legal services had to rely on private lawyers acting on a no-fault, no-fee basis, or voluntary organisations like FLAC, was simply inexcusable. Today, I think we have to accept that the situation is more complex. The dramatic changes to the legal aid system, both civil and criminal in the United Kingdom, strongly suggest that the trend is moving very far away from a model which sees legal aid as a component of a post-war welfare state and an entitlement of every citizen. At the same time, this report shows we have learned that the need for legal assistance goes well beyond the traditional model of providing advice in a room or representation in a court. My predecessor, Frank Clark, set up the Chief Justice's Access to Justice group, in which FLAC is a very important member. One of the important insights from last year's conference, to which David has referred, was, I think, that it shows that the problem of access to justice are multifactorial. There's no single solution. But in the necessary patchwork of small changes, which would be necessary to change even some general improvement, it is realistic to recognise, I think, that there will always be a place for the long tradition of Irish lawyers doing work either pro bono or no full, no fee, and always a place for a voluntary organisation like FLAC, providing legal assistance, legal advice, education, and access to justice more generally. And in returning to a theme I've already touched on, the capacity of an organisation such as FLAC, as illustrated in this report, to call on the services of law firms in this jurisdiction, or barristers, or sympathetic academic lawyers, is, I believe, an enormous strength. But what I think is sometimes forgotten is that that is also a significant benefit in and of itself to the legal system itself. The legal profession, like many professions and businesses indeed, it can be said that nearly all professions and businesses are not a perfect reflection of the diversity of the society it serves. That is something which professionals themselves must be constantly aware of and strive to change. But there is an irreducible element to it. The very fact that it's necessary to obtain a third level degree in a professional qualification has the effect of converting entrants into members of the middle class. So long, therefore, as the legal profession is drawn from a cohort of society which is different from the groups experiencing the most need which FLAC serves, then it is a real benefit to volunteer lawyers, and indeed the legal system more generally, that they and it are required to engage with people sometimes suffering very severe disadvantages and see and understand at first hand what it means not to be deprived of access to justice and access to legal aid or assistance. And by the same token, it is in the nature of a campaigning organisation that it should challenge authority to be better. It's perhaps inevitable that part of the job of FLAC is to make someone in my position feel uncomfortable. More broadly, I understand that it is the nature of things to focus on difficulties, inadequacies, and failures, and to constantly press for more change. However, I think that this day, when an annual report is being launched, is also a day to pause, to recognise achievements and some potential future achievements. First, can I mention, as David has, the Chief Justice's Access to Justice group. That's not as self-serving as it might sound, since it was established by my predecessor, Frank Clark, who is entitled to the credit. But I am more than happy to continue to support that group. Because some people here know FLAC has been heavily involved in the organisation of that group from the very outset. Perhaps not wholly coincidentally, the Department of Justice has now established a review of civil legal aid, to which David referred, under the chairmanship of Frank Clark, and Ailish Barry is a member of that group. I think that is a very positive step. Looked at perhaps more broadly, there are times when people criticise, and David referred to this, people criticise what is described as the commercial court and seek to contrast that with facilities available in other areas. But I think another possibility, another perspective is possible. One of the cases I am proudest of as a barrister is the decision that David referred to, Caroline McCann and the Justice of Monaghan. That was a case which invalidated the provisions providing for imprisonment for debt. But I left one courtroom, 4 courts, having finished an intellectual property case in the commercial court, and went to another exact same courtroom in the same building before one of the best judges in the Irish system, Ms. Justice Mary Defoe, to argue the McCann case. The judges, and indeed the lawyers, were almost interchangeable. It may be a contrarian view, but I think that a commercial division of the court system is an important component of the legal economy, and indeed the Irish economy more generally, and you may or may not disagree. But one thing that gives me a small amount of pride is to look at the areas where significant investment has been or will be made in the legal system. The establishment of the criminal courts of justice in Park Gate Street now more than a decade ago, and the proposal to build a dedicated family law complex at Hammond Lane are very substantial investments in the legal system. I like to be able to say to foreign visitors that when the Irish system came to invest substantially in the infrastructure of the legal system, it did not create a palace to commerce with a state-of-the-art technology, even though that might have been tempting. It did so in the areas of crime and where people were dealt with by the courts, whether victims, accused persons or witnesses, often come from the more disadvantaged areas of society, and in the areas of family law, where traditionally FLAC has provided most of its services. Crime and family law are the areas of greatest demand for legal aid, criminal and civil, and it is, to me at least, encouraging that the Irish system sought to invest in these areas to ensure that the disputes which arose would be determined in surroundings and conditions that respected the dignity of everyone involved. And I do think that the wide influence of an organisation like FLAC helps set the tone in which those developments can occur. And I hope that the same spirit of generosity and breadth of vision will be brought to bear in the Civil Legal Aid Review, and as importantly, in the implementation of any recommendations. And I'm sure that FLAC will contribute greatly to that process. On a personal level, I would like to recall the visit last year of retired Judge Edmund Cameron from South Africa to say how much I enjoyed and benefited from listening to him both here in FLAC HQ and also from hearing and meeting him in Blackhall Place. But I was also struck and heartened by his obvious respect for the Irish legal system. And that international reference brings me to a final point to which David also alluded. As I say, I do believe that part of the function of any group, of a pressure group like FLAC, is to make someone in my position uncomfortable, to criticise unjustified, and to hold the system to the highest standards. And I understand that the justice system can not only be frustrating and cumbersome, it can also appear like a monolith. But criticism should be fair and recognise the commitment of many people of goodwill and the value of a mature and robust and reasonably stable system. Because as David mentioned, when we look around the world, whether it is west to the US or to Eastern Europe or to developments in our nearest neighbour, I think we can see that the concept of dispassionate independent justice system upholding the rule of law is more fragile and vulnerable than any of us might have imagined even a few decades ago. And while there are times that the justice system needs to be challenged and criticised, there are also times when it needs support to be supported and defended. And if we ever have to face those challenges here, I hope and believe that FLAC will defend and support our system of law. For my part, I think that the publication of this report is an opportunity also to look at the achievements of the organisation. In my opinion, FLAC has established itself not just as an organisation, but as an institution in the Irish legal system, and an invaluable one, which over its history has campaigned for change, protected the weak, challenged the strong, and indeed educated us all. I do not have a birthday cake today, and dodgy haircuts are unfortunately no longer a concern for me. But at the risk of still causing terminal embarrassment to the organisation and to you, Chief Executive Eilish and Chairman David, I have to say that as Chief Justice, I regard it as an honour to launch this report and to have the opportunity of wishing well the organisation in the years to come. Thank you.
Thank you very much, Chief Justice. The honour is all ours. It's great to see everyone here in person, and welcome also to our many friends and colleagues who are online. As the report shows, 2021 was a really busy, eventful year, both because of the impact of COVID and in spite of COVID. We had really positive engagements with a wide range of groups and individuals, and very positive policy and casework outcomes. There's a huge learning for FLAC from the collaborations, and the end results were way more than what we would have achieved by ourselves. and possibly even at times more than what we were expecting. And I'd like to acknowledge the work we do with our EU partners, Shane and Maria Elena in ENAR, and Fiona and Samantha in their Traveller Equality and Justice programme. I know people are really witnessing the constitutional rights being taken away in the US, but I suppose from FLAC's perspective, it's really important to pause and acknowledge that last week was historic, at least I think it was, with the first meeting of the review group of the civil legal aid system. We've been campaigning for over 50 years to get the legal aid system onto the agenda. Last year, we did our best to make the review of the legal aid system an issue in the election, and we engaged in-depth discussions with civil society organisations who work with disadvantaged individuals and groups about their experience of the legal aid system. And this led to a petition signed on behalf of 45 groups, including one union, to petition the Minister for a root and branch review. And I'd like to thank Stephanie for her work on this. We were also delighted to accept the invite from the former Chief Justice to participate on his newly established Access to Justice Committee, which was a really new development in and of itself. And we were also really happy to participate in the really excellent conference which looked at the multifaceted aspects of access to justice in October. And there were really new and inspiring thinking from speakers like Professor Farrell, who set out the economic case for access to justice, and Mark Benton, who described in really innovative ways of delivering access to justice. And of course, the two Chief Justices spoke as well. It's hard not to conclude that some or a combination of all of these events put legal aid on the agenda and at least contributed directly or indirectly to the Minister changing her mind from 2020 and deciding to hold a comprehensive review, which is, as the Chief Justice and David said, has been chaired by the former Chief Justice, and which got off to a really promising start last week. Since the beginning of the pandemic, it's no exaggeration to say that our telephone information line has been overwhelmed with callers who are desperate for information about their rights, especially in the areas of family and employment law. Callers are upset about the issues they are facing. The calls are more complex due to COVID, and they're taking longer. 13,147 people were provided with basic legal information on the phone line. And of these, almost 30% had a family law query and 15% had an employment law query. It is a matter of real concern to us that we have nowhere to refer the majority of the callers to. For example, those who narrowly failed the means test for civil legal aid. And the report sets out a particular caller who was over the legal aid means test by €500 and had incurred a debt of over £20,000 in solicitors' fees, which the caller was struggling to pay. The caller was also looking at the sale of the family home and was dependent on family, friends, and money lenders to try and get through. We also regularly hear from callers who are actually entitled to legal aid, who may have been served with legal proceedings, but have to wait months to get a solicitor, and we have to advise them to go into court to try and get the proceedings adjourned, which is a knock-on effect, obviously, for them, the other parties involved, and then the court system itself. We also have nowhere to refer the 1,967 callers who contacted us looking for advice and representation in employment law cases on often very complex issues, as there's no legal aid for employment and discrimination claims before the WRC. And very often the callers are not in union, though I suspect Mick Lynch is going to have effect a big change in union membership. We've also nowhere to refer the callers who are lay litigants who are desperately trying to navigate the court system by themselves and who are completely daunted by the forms and procedures. And we don't have the resources to provide them with the ongoing detailed assistance that they need. I want to acknowledge the work of the court services led by Angela Denny, who participated in the Access to Justice Conference and so clearly articulated her commitment to putting the person at the heart of the court system. And we were very pleased to engage last year in the numerous consultations that have happened. Gillian, who's our number crunchers, tell us that the figures to the phone line were the highest logged since 2015. And now, however, we know and we're very aware that we're only dealing with tip of the iceberg, and we're keenly aware that there are significant more people trying to get through who are unable to, despite our increasing staff, our volunteers, including staff from law firms, and providing greater expertise and resources to the phone. The legal advice phone clinics were established on foot of COVID when our network of clinics had to close. And during last year, 2,729 people received legal advice through the FLAC phone advice clinics. And we are hoping that the face-to-face clinics will be open shortly. Between the phone lines and the clinics, we're seeing an overwhelming demand for legal information at an early stage, especially in family and employment law. There has to be better ways of how these services are being delivered by the state. And it's clear that there's an acute need for the prioritization of accessible early legal information and advice and advocacy by a reformed legal aid system, which, if provided in a timely, accessible way, could have a very positive impact. What is needed now is a radical reimagining of how the various aspects of access to justice are delivered, from legal aid, from legal information, legal advice and advocacy to legal representation, especially to individuals and communities who experience poverty, disadvantage and exclusion. And I think FLAC's Traveller Legal Services is a very good model, as is our sister independent law centres, including Community Law and Mediation in Coolock, the Ballymun Community Law Centre and the Mercy Law Centre with its focus on homelessness. We're absolutely delighted that the vital work of the FLAC volunteers was acknowledged by Volunteer Ireland when they were shortlisted for an award, and there was a very happy ceremony celebrating these volunteers some weeks ago. I also want to thank the firms who help us out with the phone lines and the clinics, and I see Caroline Minnick, who's here from Arthur Cox today, Niamh Coonahan and Matheson's, who are about to come on board, Mary Brazel and McCann's, and Ethlyn Lynch and Aina Goodbodies. FLAC's Public Interest Law Alliance, PILA, is a really good example of collaborative work with NGOs and advocates and who provide services to disadvantaged communities and the lawyers who act for them on a pro bono basis. During 2021, 110 NGOs received legal assistance through our pro bono referral scheme by lawyers acting privately. And Pro Bono Week and the first Pro Bono Stakeholders Meeting and NGO pitch events were also important first during 2021. Sinead will detail the work of the Independent Law Centre at the Roma Clinic and the Travers Legal Service. The Law Centre mainly deals with people living in poverty and at times extreme poverty, disadvantage and exclusion, who very often experience multiple legal issues in areas like homelessness, social welfare and discrimination. Judicial review is a really vital and often only remedy available to FLAC clients, so we view the proposed restrictions to the judicial review regime, which will make it even harder to access the courts with great alarm. Arising out of the work of the Law Centre, we're keenly aware of the deficits in the equality legislation, so we organised with the Law School in Trinity a series of lunchtime seminars, and we're delighted that Roger Cook-Vaughan announced the review of the legislation, which he delivered at the closing of the seminars, which were organised. FLAC then, in partnership with IREC, launched the Equality Action, a joint project aimed at strengthening the engagement of civil society. And I'd like to thank IREC and to Chris for their work on this very fruitful partnership. I also want to thank the LLM TCD students who produced a really useful report on levels of representation for the WRC. It's clear from the annual report just how much work was done last year. We have a fantastic, committed, very skilled staff, and I'm really honoured to be part of it. And I want to thank each and every one of you. The communication staff, Susan and Caroline, bring us all together, and I want to thank them, Liz and Karina, for organising today. I'm really sad that we'll shortly be saying sad goodbye to Maureen Gorley, who's moving on to better things. She has such a history with FLAC and is such a part of FLAC and is such a really valued member of staff. We're so lucky to have her, and I so admired her consideration, thoughtfulness, care and kindness she brought to the cases. And she showed incredible fortitude and resilience, and at times bravery, and grace at times in incredibly difficult cases. And I want to thank her and wish her the best. And I think she's sorry she couldn't be with us here today in person. We were also very sad to say goodbye to two great friends of FLAC during 2021, Frank Callan and Katie Dawson. And finally, I want to thank the unsung heroes of FLAC who carry out vital work in a very hidden way, and that's FLAC Council. I want to give a huge thanks for their support, which I must admit to taking for granted most of the time. It's a really onerous responsibility to work in a voluntary capacity as a charity trustee. A special thanks to Julie Hurley, who oversees and provides invaluable guidance on a monthly basis in relation to our finances, and to Joanne Hyde and David, who did outstanding work in the governance committee, which led to us being able to declare compliance with the charity's regulatory protocols. A special word of appreciation to David, who stepped up to being chair on the fake promises of little time commitment and mostly ceremonial duties. And I see Jodie Sotomali is here, and my only defence is it's happened before, which really isn't a defence, but just recidivism on FLAC's part and coercing people to become chairs. But I really appreciate how much time David has taken out from his incredibly busy, successful practice to do countless hidden work for FLAC, and it's hard to overstate how much he did last year and how important it was for FLAC. And I've no doubt he and Sinead would far prefer to be working on FLAC cases. So thank you, David. Sinead, our managing solicitor, will now talk about the work of the FLAC Law Centre.
Thanks, Eilish. Chief Justice, Chair, colleagues and friends. FLAC as an independent law centre takes cases in the public interest in order to make the best use of our limited resources. That being so, we target our services towards those who are most likely to experience discrimination and have their rights breached, but at the same time are least likely to have access to legal advice and representation. As this annual report shows, this is not an exclusive category of groups, but not surprisingly, the mistreatment of travellers in the Roma community featured significantly in our work in 2021, as did the gap between the rhetoric of disability rights that we're all familiar with and the frequent invisibility of such rights in reality. FLAC's Traveller Legal Service was established in 2020, just as the world was plunged into the chaos of the COVID-19 pandemic. So 2021 was the first full year in which the service operated, and it is evident that it is a service for which there is critical need. It also provides a model for how the right of access to justice for marginalised communities may be vindicated through the provision of dedicated legal services, attuned to how the law can both work against and for a community. I want to express on behalf of FLAC our ongoing appreciation for the support of all this work by all the national traveller organisations. This mutual support approach is a key aspect of the success of the initiative. So a small snapshot of the work during 2021. The Traveller Legal Service received 85 requests for assistance during the year, most of which related to housing and accommodation matters. Much of the work in dealing with these requests involved advice, guidance, support on next steps required to resolve the problem before the issue escalated to one requiring full legal representation. Of those that did require full representation, 3 involved High Court proceedings concerning local authorities' failure to deliver appropriate accommodation to our traveller clients, and one of which included a constitutional challenge to legislation allowing for arbitrary evictions without court oversight. Not surprisingly, everyday incidents of discrimination against travellers was also a significant theme in the cases handled by the Traveller Legal Service during the year, with a number of complaints being referred to the Workplace Relations Commission regarding access to goods and services, including in relation to licensed premises. As has been explored extensively by the Irish Human Rights and Equality Commission, incidents of discrimination on licensed premises are particularly difficult to pursue, as they're determined by the district court, making a remedy expensive, at least in terms of our clients, risky in terms of costs and procedurally complex for the unrepresented. FLAC echoes IREC's recommendations to repeal Section 19 of the Intoxicating Liquor Act to ensure that all complaints of discrimination are dealt with in a single cost-free forum. Our Roma Legal Clinic continued to operate during 2021, despite the challenges of having to do so on a virtual basis. Language difficulties make it very hard to deal with these clients over the phone and by other digital means. Yet again, however, the work showed that the casual racism towards Roma women was a significant feature of our casework, and FLAC acted in 5 separate cases in which Roma women were refused access to goods and services. We take these cases to highlight the issue, not least the intersectional nature of such discrimination. But we know there are many more incidents that we can't deal with, and that begs the question, what more could be done in this area? A case that demonstrated the difficulties that individuals, often travellers in Roma, but also others, experience in accessing remedies for discrimination was also settled during 2021. The case concerned Dr. Ethel Brooks, chair of the European Roma Rights Centre, and her complaint against An Garda Síochána regarding her treatment when she engaged with the Garda at passport control in Dublin Airport. At first instance, her case was dismissed in the Workplace Relations Commission as she had not fully complied with the procedural requirements of the Equal Status Act, not unusual. On appeal, a settlement was reached, including a statement from An Garda Síochána acknowledging the distress and upset caused to our client as a result of comments made to her at the airport, and committing to training of members of An Garda Síochána in relation to its responsibilities under the Equal Status Act, as well as a sizable donation to Palm Point. So while the outcome was positive for our client, it does highlight 2 important issues. The first is the barriers that individuals experience bringing complaints of discrimination before the WRC in the context of a process that is supposedly accessible and does not require legal representation. Secondly, there is an ambiguity as to the extent to which the functions of public bodies, such as An Garda Síochána, are included within the equality legislation, and whether those exclusions that exist under the equality legislation are in compliance with EU law. As a result, FLAC is calling for the issue of accessibility, legal representation, and the scope of protection under the equality legislation to be addressed in the ongoing review, as mentioned by Eilish earlier. So the gap between the rhetoric of disability rights and the practical application of those rights was to the forefront when FLAC provided advice to a couple planning to marry in 2020. That couple had been in a relationship for a very long number of years and were deeply committed to each other. However, both had Down syndrome. On the eve of the planned marriage, an application was made to the President of the High Court by the care facility in which one of our clients lives to stop the marriage. The injunction was granted and was very quickly followed by a petition to the High Court to inquire into whether our client should be made a ward of court. This would have resulted in our client being automatically excluded from marrying while under the protection of the court, as well as losing independence in many other areas of his life, an independence he very much enjoyed. The proceedings were complex and challenging, but resulted in an application to the Court of Appeal to put a stay on the inquiry into wardship, pending the determination of a separate constitutional challenge commenced on behalf of our client, asserting that the global removal of our client's decision-making autonomy did not respect his fundamental rights, not least the right to marry. That challenge resulted in the repeal of the Marriage of Lunatics Act 1811 in February 2021, and everybody should note the gap between 1811 and 2021. That's quite a period of time for legislation to continue on the statute books. And a commitment from the state to commence the Assisted Decision-Making Capacity Act 2015 in early course, abolishing the wardship jurisdiction to be replaced by a more rights-based approach to decision-making for persons with a capacity issue in line with the requirements of the UN Convention on the Rights of Persons with Disabilities. The commencement of the 2015 Act is expected during the course of the next few months. And on that basis, both the wardship inquiry and the constitutional challenge has been adjourned. Our client will never be made a ward of court, but only because he had access to legal representation. A matter that we know in FLAC is all too often a matter of chance, and I suppose that's why we exist in the first place. This case is also one of the last opportunities that FLAC had to work with Frank Calman, Senior Counsel, who died prematurely just before Christmas 2021. And I know Eilish mentioned this already, but it is fitting that Frank is remembered in our annual report, side by side with the Wardship case. Frank's commitment to this case and fearlessness in the face of considerable resistance to the mere assertion of our clients' constitutional rights kept us all buoyed up. And it would have been a lot easier to bow to the immense pressure to abandon the case. He was the ultimate advocate and he inspired us all. By way of closing, I want to pay tribute to the immense work of my colleagues during 2021. Eilish, who provides constant moral and practical support in advancing our casework. Maureen Gurley, who Eilish has already paid tribute to and who leaves us this week. Christopher McCann, who in a very short time has become an essential and trusted support to the traveller community in advancing their rights. Christopher Bowes, for capturing the outcomes of our litigation work through the development of compelling evidence-based policy positions, something we never managed to do previously. Thank you all for your dedication to our work, and thank you all for this.
And a huge thanks to our managing solicitor, Sinead Lucy. We couldn't manage it better at all. I'd like now to introduce Paul, who's our Senior Policy Officer, who's done incredible work in the area of debt, and during 2021 produced 3 papers in series pillar to post. And before that, can I just mention, as Susan rightly pointed out, I had it in my notes, but one of the most exciting collaborations is with the FLAC societies in the universities, and we started good work with them last year, and we hope to develop this work in this year and next year, as they are very much the future of FLAC. So, Paul, I'm over to you.
Chief Justice, ladies and gentlemen, very good morning to you all. Special welcome to Lisa O'Malley, long-standing chair of FLAC. Very good to see you here. My purpose this morning is to speak a little, hopefully not too much, about FLAC's policy and research work in the area of debt and personal insolvency during 2021, and the relevance of that work in 2022 and beyond, particularly in light of the changing economic conditions we now face that threaten another financial crisis. In the course of 2020, as COVID took hold, it was clear that it would bring adverse financial consequences for some borrowers, particularly those on low and precarious incomes. We have been concerned for some time about the cautious response of the state to resolving consumer insolvency and family home mortgage arrears in the aftermath of the global financial crisis in 2008. While some improvements have been made over the last decade, excuse me, they have not been adequate enough. We felt that a detailed review of the debt resolution system is timely, and in consultation with our colleague Dr. Stuart Stamp, independent social researcher and research associate at NUS, we devised a pillar to post series, a title intended to reflect the ongoing struggle of many borrowers to return to financial solvency and the renewed threat of insolvency for some. The series takes its starting point that consumer debt is and will continue to be a constant in our society and economy. Borrowing to fund the purchase of goods, services, and property is an integral part of our economic model, which itself is cyclical in nature and is significantly influenced by global events beyond our control. Current adverse events in the macroeconomic environment, galloping food, fuel, and energy inflation, and excessive housing costs filter down into everyday lives, and for some, the sums no longer add up. If our system of resolution does not react and adapt to these events, it is failures. Just some detail now about the papers themselves. In paper 1, published in June 2021, we set the context for the series by gauging the extent of consumer apprehension pre-COVID and the evidence for it. We charted the perception of existing financial difficulty in the period immediately before the pandemic hit and perceived fears subsequent to COVID's arrival. We tracked and analysed the PUP payment in terms of recipients and sectors, the employment wage subsidy scheme numbers, rates of unemployment and COVID adjusted unemployment, data on rates of utility debt arrears and disconnections and fears for small business and personal insolvency. We also observed the phenomenon of the incubation of debt, the tendency for some in difficulty to postpone seeking help, a trend which may be reflective of COVID-19 itself, where by necessity people stayed at home and avoided the outside world, and where remedial services themselves went online and face-to-face engagement was largely suspended. In paper 2, published in August 2021, we focused on attempts made between 2011 and 2021 to resolve the family home mortgage arrears crisis arising out of the global financial crash and the struggle of many households to remain in their home even in the face of prolonged litigation. This exploration illustrates the undue caution employed by the state in the attempted resolution of that problem, an approach that sought to avoid the repossession of family homes in any significant number, but also declined to facilitate the write-down of impaired mortgages, irreconcilable aspirations in the long term. The ongoing failure of housing policy in Ireland has provided a substantial obstacle to the effective resolution of arrears during this period. Had there been alternative, affordable housing options available, many borrowers might have been saved the trauma of defending their position. But the truth is that such options did not and clearly still do not exist. The coming into operation of the personal insolvency legislation in late 2013 saw the introduction of a statutory personal insolvency arrangement intended to resolve cases of secured debt. Excuse me. However, because a sufficient threshold of creditors could vote down the proposal and no right of review or appeal was available in the courts, numbers of approved arrangements were considerably less than forecast. An early 2016 amendment finally allowing for a court review has helped, but structural difficulties in the legislation continue to exist. The most significant of these currently is that many properties are now in positive equity, allowing the lender to argue that repossession of the dwelling provides a better return than any proposed arrangement. Recent High Court jurisprudence acknowledges the conundrum, and the current statutory review of the Personal Insolvency Act must introduce and explore reforms. A perception has developed in some quarters during COVID that the mortgage arrears problem is largely solved, influenced perhaps by the relative absence of new possession orders and the enforcement of such orders during the quiet period of courts. The data, however, firmly indicates that long-term arrears cases remain problematic. This is summed up in the most recent Central Bank of Ireland figures that 21,000 plus accounts, 45% of the total in arrears, were deemed to be cooperating by their lender but had no agreed restructure in place at the end of 2020. With imminent and potentially extensive ECB interest rate increases at our door, mortgage arrears needs to be watched very carefully. In paper 2, we also examined the Land and Conveyancing Law Reform Amendment Act 2019, legislation that in theory allows the circuit court to refuse to grant a possession order to a lender, even though the borrower continues to be in arrears, broadly on the grounds that the lender has failed to properly engage with the borrower and considered all available options to avoid repossession. 3 years after coming into operation, this act remains unused and unlitigated, hindered in no small measure by the failure to put in place circuit court regulations to clarify the procedures that would allow borrowers to argue this act in their defence. This also needs to be remedied. Paper 3, published in November 2021, examined central bank data on the payment breaks availed of by borrowers during the initial phase of the pandemic, from the end of March 2020 to the end of 2020. A number of important facts emerged from this analysis. Over half of the accounts where borrowers had sought a payment break on their mortgage by the end of May 2020, that's almost 36,000 accounts, and they drew down their mortgage in the pre-crash period from 2004 to 2008. This clearly suggests a vulnerability to recurring financial difficulty and an age profile that would give rise to significant concern for these households. Research data published in 2021 by the Central Bank itself reinforces these concerns. In one recent CBI paper, the extent of the potential outstanding liability at the end of the mortgage term of close to 100,000 accounts is outlined, with particular fears expressed for aging and older borrowers. Notable too is that the CBI payment break figures did not include mortgages owned by non-banks and funds, an omission that the bank still has not explained. Over 2/3 of mortgage accounts in arrears of over 1 year are now owned by non-banks and funds. And they also own 2/3 of the accounts the subject currently of legal proceedings. In terms of payment breaks on unsecured consumer credit loans, it is significant that some 17,000 accounts that availed breaks resumed payment only on an extended term by the end of 2020. Again, an indicator of future payment problems. It has also become apparent during this analysis that there is no central bank data published on the numbers of unsecured consumer credit loans in arrears, an omission that also requires explanation. If the extent of a problem is uncharted, it's hard to devise a coherent resolution strategy. With the focus on mortgage arrears cases over the past decade, there has been insufficient consideration of those without mortgages, but experiencing difficulty meeting their various financial commitments. Significant numbers of households were concerned about their position before COVID arrived, and 2 years of the pandemic, followed by current adverse events, would not have rearranged this. These are not the households whose deposits accounts reportedly bulged with cash because successive lockdowns restricted their social lives. These are households where incomes were tight to begin with, and where a layoff or short time because of COVID restrictions used up any savings there may have been. There must now be a renewed focus on the resolution options under the personal insolvency legislation for those with unsecured debt. That is the debt relief notice and the debt settlement arrangement. And these processes must in turn be reformed. Finally, in paper 4, currently in the course of being finalised and likely to be published in the early autumn, we conduct a detailed review and assessment of the services available to assist people in financial difficulty and to help negotiate and resolve their debt. This includes the Money Advice and Budgeting Service, the WALIA scheme, the Civil Legal Aid scheme, and the legislative and quasi-legislative processes in place to facilitate resolution. Regulatory codes such as the Code of Conduct on Mortgage Arrears, Personal Insolvency Act as amended, Mortgage to Rent scheme overseen by the Housing Agency, and also debt claim and debt enforcement procedures in the courts. Key objective of this final paper to end series is to make evidence-based recommendations for reform viewed from the debtor advocacy perspective. In a research report published last week, reviewing the effectiveness of the low income, no assets debt relief notice mechanism, commissioned by the Money Advice and Budgeting Service and the Citizens Information Board, and authored by Dr. Stuart Stamp and I, we observed that personal debt problems emerge in the main as a result of things that happen to people, rather than things that are done by people. And particularly so in the case of those who are in precarious or marginalized situations to begin with. The reality of that statement needs to be firmly borne in mind when devising solutions in the period to come. Thank you for listening.
very much, Paul. I'd just like to conclude the launch by inviting you to listen to the words of one of our callers who got through to the FLAC information line during 2021. We're always very reluctant to ask people to speak about their experience in contacting FLAC for very obvious reasons. But this was one person who was actually willing to speak, though we have changed her voice in order to protect her anonymity. And I think it shows, I suppose, the experience of people contacting FLAC and also the value of the work that FLAC does. It concerns, the person concerned has a query in relation to domestic violence. And I do want to point out that the Legal Aid Board prioritise domestic violence cases. But like many other callers to our phone line, she had no idea what her remedies were or what was available in terms of legal aid. Thank you.
It would have been ongoing abuse, both physical and emotional. Me and my partner were living together in the countryside. We were married and we had one young child. For months I was living in fear. It just felt like something bad was going to happen. It was his mood. I didn't know what would happen, but I knew it wasn't going to be good. The last thing that did happen was in a public place, and I just knew that if he would do that in public, then what would he do when he got me home? I went to my parents and I told them, and they said, enough is enough. This can't go on. I was terrified. I was desperate for help, and I was sick to the bottom of my stomach. I left my home and I moved back in with my parents. I knew I needed legal advice in order to protect myself and my daughter, but I didn't have a clue where to go. At the time, getting money to pay a solicitor would have been very hard. I was a stay-at-home mammy. We didn't have a joint account. The money wasn't ours, it was his money, and I had no access to it. Then my mother did a Google search, and FLAC came up. Mam rang the FLAC phone line and she got speaking to a woman there. The woman asked to speak to me. I told her exactly what had happened, and she broke down all the steps that I needed to do to protect myself and my daughter. Her advice made me feel like, it's not overwhelming. It's manageable, and there are things you can do, and that gave me a bit of hope. She told me to ring the court and get an appointment to see about a protection order, and I did, and I got an appointment to see the judge the next day. Since then, he can't contact me or make any contact with me, and it does feel like I'm safe for now. There will be more hearings, and I still feel scared because of what lies ahead, but it's a great relief to feel protected. I had no idea that these things were available to me. The law is very hard to understand. There's so many ins and outs to it all. You kind of need it explained in a way that's easy to understand, and you need someone to be patient with you. Only for FLAC, I would still be back in that situation. He'd be making my life hell, and I would be very, very vulnerable. I think that's what happens to lots of women, because you don't know what to do. It can just be really, really hard to take those steps. I'm very happy, though, that I got through to the FLAC phone line, because I literally had nowhere else to turn.